Robert J. Hill on behalf of Donovan Smith, Donovan Smith.
All right. Okay. And is date and time set for preliminary examination, both these matters?
There was a previous offer made to my client, which I took to my client to the jail, and I asked him again if he wanted to take advantage of a possible hideout plea. Mr. Jablowski.
I remember now. That's why I recorded it. They were offering him the Home Youthful Trainee Act, and for some reason he's saying no. I don't know why, because that drops, if I remember correctly, it drops the conviction off your record if you complete probation and pay off your fines. So that would be crazy not to take that unless he knows for some reason he can win at trial. But that's where things get kind of complicated with court. If you get in trouble a lot, you have to really kind of know what you're doing to be able to play that game with them. It's kind of like playing chess with the court. And you have to really figure out what they have and say or do things in a certain way to try to get the best outcome for you. But yeah, going to trial is not something that's always easy to win unless he was wrongfully arrested, or of course if it's like murder charge, anything like that, you want to go. If you're really facing that much time, you always want to go to trial. But yeah, I don't know why he's not.
For the purpose of the record.
Judge, I did make an offer to the defendant as an alternative. He can plead, and I apologize. I don't know.
I got it here, Alex.
Thanks. It would call for, in case number, so either would call for Mr. Smith to plead guilty to discharging a firearm at a building, the 10-year max. In case number 25F21637FY, with an agreement to sentence under IDA, the Homes Youthful Training Act. And my office would then dismiss the remainder of the charges, which are an R&O, a 2-year max, carrying a concealed weapon, 5-year max, and possession of a firearm by a prohibited person, also a 5-year max.
So what was it, like 10-year max, 5-year max, 2-year max, another 5 or 2-year max? Generally, whatever he gets sentenced on the 10-year one, they would run everything concurrent anyway. Where if they run it like consecutive, you have to do the time for one of them before you start your time for the other one. They usually run it concurrent, so it's kind of not really a huge deal. Dropping those, it's not quite as good as what it sounds, but it does take all those off his record. Which if they were going to get dismissed anyway, I don't know. I don't know why they're doing it this way.
Or Mr. Smith could plead guilty to resisting obstructing an officer at 2-year max in case number 25F21637FY. And I wrote it as carrying a concealed weapon in case number 25FB2506FY with an agreement to sentence under the Homes Youthful Training Act and dismissal of the remaining charges, which were discharging a firearm in a building and possession of a firearm by a prohibited person.
Not 100% sure, but I thought CCW was 5-year max. I don't know though, but I mean, if it is, take that one, but it doesn't seem like he wants to take a deal anyway though.
It's my understanding that Mr. Smith is not interested in that.
Mr. Smith, you and I went over those proposed plea agreements, right?
Can I?
That's weird. That's
Before
such
you
weird
go to
agreements.
why they're declined, I don't know. Mr. Killowell, did you voir dire him in the context of a probation violation that he has out of Wayne County?
I wasn't aware of that, no.
Okay. So my understanding is he has a probation violation I'm not clear what for out of Wayne County.
I may be able to advise to the
Go ahead.
court. At the time of both of these offenses, it is my understanding the defendant was on bond from an Oakland County case number 25292-636-FH. He had pled guilty, or he had pled guilty plea on the ROA, the Register of Actions, to unlawful driving away of a motor vehicle he was found guilty on September 4th, 2025. This incident date is like the 30th.
Pardon?
The incident date on these cases is the 30th
Of September.
2025.
But he was sentenced.
He was sentenced in November of 2025 for the UDAA on November 6th. So I don't think this would necessarily be a probation violation, but I don't know if the hold is just pending figuring out what's going on.
Well, the information that we received is that it's a probation violation. And with no bond. But
The case that he's on probation in Wayne County for is the Oakland County case. Yeah.
Oakland County?
It looks like he got transferred to Wayne County.
What are you doing for? CCW, I don't know, you pled in Wayne County?
On a HIDA.
CCW.
Oh, I didn't have that.
When that was? Or
Did he just say he had another CCW?
And I didn't want to cause any confusion. I just wanted to make sure that whatever conversation he had with your client about a possible resolution here was taking into account everything that he has. I was not aware of, I don't think I was aware of the Oakland County issues. We were just informed that he has a no bond hold in Wayne.
Judge, my client, I believe, did tell me at one of our visits at the jail, but nonetheless, he's not interested in the offers or anything like
Right, I just want to make sure that what.
That's crazy. He's already out on bond. I could have swore he said the other case was a CCW, and now if he's got another one, unless I misheard him, but I don't see you winning at trial unless you were wrongfully arrested. And the no bond thing, they do that here too. So I live on the border of two different counties, and one of the counties is really lenient. And if you basically get a probation violation, they won't do anything. They'll just say that they'll wait and see how it plays out. And the other one, if you get another charge, which would be a probation violation, it's automatically no bond. And that's what I meant to say the first time too. If you get a new charge, which would be a probation violation, not if you get a probation violation, but either way, the point is one county is like super lenient, the other one is the complete opposite. So one of them won't do anything and the other one will put you on a hold, which really sucks. Plus the time doesn't always count when you're on a hold.
Whatever conversation needs to happen, because I don't know what that's about. I can't see it to say why he has no bond on that case.
careful what you say, but if it's regarding that, what are you saying? Stand up first, you're talking to each other.
It's no bond because if I'm gonna be charged with CCW and shooting into a building, then that's of course violating my probation. So Even if I take.
Right, no, I hear you, but is that the reason it's no bond is because of these cases?
Yes.
I see. Okay. So the deals you offered, that doesn't even make any sense. So council approach, please. Record should reflect we've had a bench conference in this case, and I realize that there's been an offer extended. I realize what the defendant is saying now, okay? Young man, just listen to me for a second. And why I asked your attorney whether or not he knew about that is because that the Wayne County matter can have certain implications for you. Okay. But because your attorney doesn't know about that, he wouldn't have had reason to necessarily investigate what those implications are for you. Okay. And because of the way that the statute, the HIDA statute reads, as I see it right now, without going into all of the way things play out, you could end up with a number of convictions and no HIDA. Okay? I don't think that's what you want, right? And that's what I was getting from what you said before about why you may want to do this. It may be, okay, and your attorney's going to check into this, that, and I'm just going to give you a hypothetical, okay? I'm not saying you're going to do this or anything. That if there's a plea in this case or in these cases, you could maintain a HIDA here, but then lose that one in Detroit. Then the question becomes, what happens to you? What's the probation department going to do? Okay. Otherwise, what you could do, you go through and fight these. If you get convicted, you would get, chances are you may not get HIDA on these, and then you lose that one there, right? Which would not, I know you don't want that, right? So
That makes so much more sense now. I was wondering why he was turning down a really good deal, especially to get something off your record, because that was a big problem that I had because I was part of a criminal organization for 17 years. So when I got out, I had a really long record. Plus, I had a lot of other issues. I had bad credit because when I went to prison the last time, I lost everything. Like, everything went in default automatically. It's my apartment, car, credit cards, phone, everything automatically went into default because I wasn't there to pay it. So then when you finally do get out of that life, now you have long criminal history, multiple felonies, you have bad credit, so you're already kind of starting in the negative, trying to start your life over, and it takes a while just to even get back to zero, basically. And being worried about losing the Youthful Trainee Act, that makes a lot more sense now. Why he doesn't want to do it that way.
and I've just given you sort of a thumbnail of it. What I don't want,
But still, like the judge said, if this is going to be a probation violation on the other one, which it would almost have to be, then I feel like he would still want the deal on this one. Because the other one already knows, obviously, he has a hold. Because I've done it before where I actually got arrested in a different county once, and they ask you, you know, are you on probation? Do you have a criminal record? I said no, even though I had a huge record. And I don't know how they didn't notice and how it worked out, but they actually ended up putting me on probation in that county. So I was on probation in 2 counties at once. But they obviously know about his already because he has the hold. So I feel like it'd still make more sense to take the deal on this one, because this case is going to get him a probation violation on his other case, which he'll then lose the Youthful Trainee Act. So yeah, he should take the deal on this one. I'll have to find out when he gets sentenced. I mean, I guess I wouldn't find out at sentencing anyway, but I'll have to try to find a way to see what happens with all that later.
To have happen is for you to be making that decision without a full discussion with your attorney who just found out about this. And he's going to at least have to make a phone call to try to figure out what's going to happen and when. Yeah.
I don't want him to even waste his time. I don't, Agent. I don't.
What?
I don't want him to even waste his time.
It's not a waste of time. He's got to advise you.
I don't want.
He's got to advise you.
What the judge is saying, you could fight this case, but if you lose it, you have Detroit. He's just saying that you make a phone call, see what Detroit's going to do. I think it could be a good one. You know you want to fight these cases, but the judge wants to make sure you know the ramifications of Detroit decision in case you lose.
So I can have a fair chance.
That-
to know what's going on.
What?
So I can have a fair chance to know what's going on.
Exactly. I mean, that the problem is this case came back, we set everything real quick, but then there's this other stuff out there. And, you know, part of my job is I got to be fair to the people, I got to be fair to you. And so and if I feel that something's not fair, I'm not going to head down that path. That's my job. Okay. So what I'm going to do, we can consider it, I'm going to find good cause given all of that. I'm going to adjourn the prelim today. Just listen. And here's the reason why. If I thought that that was going to penalize you, I wouldn't do it. Problem is, you're not going to go anywhere anyway, because you're on a no bond hold. They're going to keep you here. So if I thought it was going to keep you in, remember, I'm the one that gave you the bond I gave you, right? So I'm not trying to keep you anywhere, but I got to make sure that you know all of this stuff. Yeah.
If my mom talked to my PO, and if this makes it past prelim, then they're gonna come get it. But my PO is being fair with me.
Well, I don't know that they're going to come get you.
I'm telling you, she said that my PO said.
POs could say a lot of things about coming to get you. That's not necessarily whose decision it's going to be. All right. I'm just telling you. Young man, here's the thing. You're rushing, trying to make certain decisions. You got a brain, you need to think it through.
I'm not sure what he's talking about with them coming to get him, because usually when you go to court, if he had to go out there for like an arraignment for probation violation, you would go there and come back the same day. Usually, so I'm not sure what he's worried about or talking about with that.
You need to talk with your attorney to try to figure it out. I understand your mom may have had the conversation. I'd feel a lot more comfortable if your attorney had the conversation about what they intend to do.
Forget about the kids. We never offered him. You get convicted, he's worried about what Wayne County. You're not going anywhere because Wayne County says. Right down to mom's phone number. And I was.
That's why, can I just say this? One of the reasons you're still here, because remember, the bonds I gave you, you could post and get out, right? And you have to ask yourself, why are you still here? You're still here because of that Wayne County phone.
Right,
You're not going anywhere.
right. They said, sorry,
Go ahead.
they said, if my PO said this directly, if this is like made over to circuit court, then she's going to come get me. I'm gonna be violated for probation. And that's of course not making a deal as well. But I said, can she be fair? Can she please let me make it past preliminary exam? And if the charges are dropped, then she's not violent. She said that she would.
But she didn't tell you that.
Tell my mom that. I'm telling her.
See, is your mama?
Your mom must know. Phone number.
Yeah, I still don't get that part because even if he,
Judge, while we're waiting for, there's one other recommendation. You were gracious enough to give this young man a PR bond. We all expected him to get out.
Released. I'll set it. I'll just,
$100 bond?
yeah, I'll just make it $100 bond. So he's getting credit.
That's
You
on-
understand that, young man?
That's on case 25.
See, this is why you need to, you've got a very good, very experienced attorney. You need to listen to him. Okay? Because I think you're making decisions based upon what you see and not understanding everything. All right, that's what I'm seeing. So the reason that he's asking for the bond, I gave you a PR on the one case. Since you could be released on that case without posting it all, right? You're not getting credit on that case for the time that you're in. So what he's asking me to do is to give you a nominal bond of $100 so that you at least are getting credit while you're sitting there. Follow that? Okay.
so yeah, what I was gonna say before they started talking again is even if they pick him up, he goes out there, he pleads not guilty to the probation
My next
violation.
date that I have, and I can,
And he'll
which
be
is
sent
what-
back by
when it
dinner
would have
time.
been set, other than trying to get everything set, is February 3rd. Will that work for
I'll have to remember that
Mr.
February
Chmielowski? Will
3rd.
that work for your witnesses? All right.
I think I have another case marked down February 2nd for us. I don't remember what that one was for though, but I got it stored in my phone.
Joe, that he not be released to Wayne County? Is that possible?
I typically don't get involved in that, so it's usually that they won't release him. What Wayne County's not going to come and get him because they know where he is. They put their hold in. Once we're done, then they're going to come get him. I mean, we done. I don't know where in the process they're looking at trying to do that.
Yeah, again, I don't know what they're
One last question.
getting at with that. If you're in jail, you're in jail. They usually won't pick you up. You'll just get transferred back and forth for court.
I think the judge is saying that because you haven't been adjudicated, if there's any movement on this case, Wayne County can sit, like you sit here.
They're not, because they can't.
I feel like he's worried about it for nothing.
That's what I'm doing. And I'm just doing it. Quite frankly,
Unless I'm forgetting about
you
something.
need to start listening to folks. And when I'm saying that, young man, you need to start listening to folks that have law degrees. you're listening to somebody else, right? And you need to start listening to that man sitting next to you about what you should do next. Because right now, as I see it, and what you're telling me, you're making all the wrong calls. I gave him the 25 personal on the
Yeah,
W.
25 Old Street.
I'm gonna change that bond to $100 cash as surety. I'm going to adjourn the preliminary examination to February 3rd, 2026 at 9 a.m. Let you check all of that information out. And I don't have a problem going forth, but let him do it with everything in front of him as to what was gonna happen. Right?
Adjourn to February 3rd, Judge, 9 a.m.
9 a.m. before me on both cases.
Oh, they're two separate cases.
Yes, sir.
Are you able to make the the change to the $100 effective last week, Thursday, so he gets all his credit? It's like it's 4 days, but it's 4 days. I don't know if it is, or we just have to fix it later.
Judge, this young man is saying he gave PR bonds on both cases. I don't recall that.
No, I didn't give him a PR on the
50,000, 10%.
right. I gave him. Well, no, I see it. I did. I gave him a PR on both cases. That's so he shouldn't even be here right now.
I thought you had left the 50/10.
No, I'm looking at the Caro, and it was $25,000 personal recognizance on that one, and on the other one, well, no, something's wrong here. That's not right. I think they got the wrong.
I thought you
They
said
got the wrong amount. What do you have on that bond? The 1637 should have been left the same because you said that you could post that one. That was the one I had already used. The new charge that came up was it was the court's intent to do the PR. Correct. And so on 1637, that bond should have been the 50,000 cash surety because he was going to be able to post that.
Yes, that makes more sense too. It was two separate
So bond
cases.
will be continued on that.
The way they were
case,
wording
that
it at
being
first was almost making
1637
it sound like they were
at
giving him a
50,000.
choice with the plea bargains,
Cash
which
surety.
didn't make any sense because they never gave
That
me a
case,
choice.
because that's the one that he could post, right? Then the other case, what I'll do is I'll increase his bond to $100 cash surety, and I'll do the bond.
I mean,
We were
if he
here
has
on
two
Thursday,
cases
what day
plus
was that?
probation,
8th,
this guy might be going away for a while.
non-protunct, to January 8th, so he'll get the 4 days credit on that since
There's no
since
way
he
he's
hasn't
getting youthful
been
training
released.
on all of it.
Judge, on the first case, is it 50,000 or is it?
It's 50,000 cash surety.
No, you took away the 10%?
It was, I don't think it was 10% before.
Yeah. What you raised it for?
I just want to make sure I heard you. Jeff.
Hang on a second. Let me
Notes from Christmas, the 23rd.
make sure, because it should have been a bond form in here.
On the 23rd, I had 50.
What do you have?
Like, depending what his record is, you know, if he
That's
doesn't
where
get
I'm
the
gonna
Youthful
put it.
Training Act, having 1 or 2 cases is not the end of the world.
Those bonds should have been
It still sucks, but in Michigan now they have.
10%. And then his bond
Oh, I
will
forgot what it's
continue at the
called.
$50,000, 10%. I knew he had to
They
post.
just
I
passed
knew
something though where it falls
post
off
was
after like 7 or 10
$35,000.
years.
So that will be the 10% bond on that one. The other one raising to $100 so they can be credit retroactive to the 8th. Yeah.
I can't post that, the first bond. Sorry.
No, don't be sorry, you can't post, give him credit, you should not post it. You know what I'm saying, that's how bond works. If he says bond. You understand what posting bond means?
That 50,000, 10%.
Right, you can't do that. So in return, you know, while you're sitting in jail, you get credit, but you can't post it.
All right. Thank you. We'll see you in a couple of weeks after they check on the thing, young man. Thank you.
Thank you, Judge.
Clean slate law, that's what it is. Which I have to look into that for my record because the clean slate law that they passed is supposed to drop stuff off your record after a certain amount of time. And I'm not sure how many things drop off. Yeah, I'll have to look into that and see how many dropped off mine. The crazy thing when they passed that, I had a case from like 15 years ago that I guess I owed money on still and I'd forgotten about it. And I must have been in jail when I was supposed to pay it, and that's why I couldn't pay it. And they never said anything, they never sent me anything. And then when the clean slate thing passed, all of a sudden I got a letter in the mail from court saying that I owed them the $1,500. But yeah, that's it for this one. You know, if you guys have any questions about court cases or have any questions about anything relating to me, just let me know. I have no problem with talking about as much as I can, and I'll be as honest and open about as much as I can. There's some things that I can't talk about, but the majority of it I can, so especially anything that I was already charged and convicted on. I marked down his court case, so I guess we'll be back with his on February 3rd.